Corporate Conversations is a new format webinar and podcast, available both live and on demand, that combines the best of the fireside chat format with the utility of the Ask Me Anything presentation. Designed to dive deep into the topic in question and deliver contextualised, relevant and up-to-date information on critical issues in a concise 30-minute format, the Corporate Conversation series will build into a resource library of crucial discussion of the most pertinent contemporary legal topics. We invite you to take a look at the second episode featuring Elena Iacob, Head of Legal at Alliance Healthcare Romania, speaking to Oana Bucsa, Senior Associate at PeliPartners, on how GCs can boost business through competition law compliance.
Welcome everyone to a new edition of Corporate Conversations sponsored by Legal 500. My name is Oana Bucsa. I am a Senior Associate with PeliPartners in Romania, and today we will discuss about competition compliance, focusing on activity of Romanian Competition Council. I will introduce my guest in the following moments, but for the time being, I would like to thank Legal 500 for these corporate conversations, which allow us to introduce general counsels across various industries and allow them to share their valuable input. As indicated earlier, today we will discuss about competition compliance. And I would start by saying that competition compliance has remained a hot focus of companies in the past years due to the constant enforcement actions of competition authorities. Only last year, for example, the Romanian Competition Council has finalized a number of 13 investigations on sectors such as e-commerce, pharma, or financial services, and has applied a total value of 83 million euro of fines. Such decisions are a constant reminder of the fact that competition rules apply to every market player, regardless of its size and its activity. At the same time, the investigations carried out by the Competition Authority in Romania shows us that most of the times companies are not being sanctioned for intentionally breaching competition rules, but for the fact that they were not aware that a certain conduct was anti-competitive. And when we refer to conduct of companies, we do not necessarily have in mind the conduct of a specific representative or director, but also the conduct of employees, for example, employees in sales or acquisition departments, given that even they interact very frequently with other companies and other competitors, and also their internal communication within the organization, and also their participation to actions such as tenders or trade associations may bring competition risks for a company. And this is because under EU and Romanian competition rules, liability for competition law does not intervene only in case of actions of persons who have, as per the Articles of Incorporation, representative powers. The action of any employee within a company may pose it to competition concerns. Having this in mind, more and more companies have understood in the last years that it's important to have in place a competition compliance program. And to come to their support, the Romanian Competition Council has issued several guidelines focusing on showing companies how an effective competition compliance program should look like. And most recently, the Romanian Competition Council has also issued some guidelines for participation in trade associations, as it has noticed that a very important number of competition breaches have taken place when companies met within specific industry associations. And what we have learned from these guidelines is that the most important factor to be taken into account when implementing a competition compliance program is that it must be tailored to the activity of a respective company. Depending on the sector of activity where a company is present, we may identify specific risk areas. For example, if in a certain sector there have been previously identified infringements of competition law, this is an indicative for companies that they must look at the respective behavior and take measures in order to avoid it. At the same time, the position of the companies must also be taken into account when understanding the type of competition procedures and rules that they must put in place. For example, when dealing with dominant companies, they must take into account their specific responsibility on the market and must make sure that their policies, their commercial policies, do not lead to conducts which may be viewed as abuse of dominant positions. Lastly, competition compliance programs must address also the conduct of companies when faced with inspections from the Romanian Competition Authority, as there have been several decisions where even though companies were not found to breach competition rules, they were sanctioned for not knowing their obligations within done remits. And this is why during competition compliance program and trainings, it is important for companies to cover this matter as well. About this and many more matters related to compliance, we will discuss today with Elena Iacob. Elena Iacob is Head of Legal and Compliance Manager with Alliance Healthcare Romania. Hi, Elena. It's very nice having you today with me.
Hi, Oana, and hello, everybody out there. Thank you, Oana, and thank you, Legal 500, for the opportunity, for the chance to having this conversation in a friendly environment, and having the opportunity to sharing my views based on my experience so far with you. Thank you very much again.
I will start the session of questions that I have prepared with a more general one. I would first want to know if, in your view, the current competition law framework accommodates the business's needs, and if there are any areas where reform or more guidance are needed.
I strongly believe that the legal framework in general, not only in the competition area, has to address clarity and predictability to those who have to follow, to observe the legislation, the rules, the principles, the obligations. And considering that, as we can see in the legislation development, the laws are more and more providing for sanctions based on percentage out of the company turnover or on high-level fines as absolute amounts. I believe that this clarity and predictability of the law is critically important for the legal framework. And there is some room for improvements when it comes about the competition law in terms of clarity and predictability, in order for the ones who have to implement, to follow, to observe the law, to know very clear exactly what they have to do, what they have to observe, what they have to consider and to implement.
So maybe the Competition Council could come closer to businesses and come with more guidance on how the law should actually apply in order to avoid sanctions being given for misinterpretations of the law, I would say. Okay, another question that I would like to ask you is what are the primary tools, technology and guidelines used to ensure competition compliance across all functions in your organization? And what are the most frequent compliance challenges faced by general counsels?
In general, a compliance program is definitely a must-have. It is mandatory to support sustainable business growth. And creating the right environment in order to mitigating the risks and protecting the business starts with a tone from the top. It is with the leadership of a company to set the culture of integrity, of ethics, or in one word, with the compliance culture of the company. Of course, that this is something maybe that sounds metaphysical, but this compliance culture should be further translated in a very robust and complex compliance strategy. And the strategy means policies and procedures related to the principles, the guidelines to be implemented, to be observed by the whole organization when conducting its business. It's, of course, about the training programs addressed to the employees in order to send to the employees, to make available to the employees the needed know-how, the needed explanation, the needed explanations, and in order to be clear for them what they have to know, what they have to follow, what they have to observe in their roles, in their jobs. And it's equally important, in my view, not to only send to the people or address to the people what they have to know, what they have to observe, but it's equally important to tell to the people why it is important for them, for the business, to observe and to follow those rules, those guidelines. And this should come hand in hand, the what and the why. And of course, that in the end of the day, each and every employee in the organization has a role to play when it comes about the compliance program, the compliance strategy of the company, and observing and implementing and walking the talk in this direction.
Thank you. Moving forward, I would want to know what are the most important actions to take to ensure that advice from external counsel is implemented effectively throughout the company, particularly around competition law. How can general counsels and legal teams make legal terms easier for employees and stakeholders to understand and comply with?
First of all, I would say that the external consultants, the external advisors are an extension of the in-house legal team. And I cannot see them working otherwise that together as a one team, giving to the organization, to the stakeholders, the best consultancy, the best solutions, and helping them to understand what are the rules to be followed when they are conducting their jobs. And here there are several tools that can be used in order for the setup between the organization itself, the internal stakeholders, and the in-house team and the external consultants to be made, the link to be made at the end of the day. And here we can talk about the communication within the organization, yeah, with the internal stakeholders, providing them with opinions, recommendations, conclusions of the assessments that the external consultants have provided, and also by direct interaction between the in-house legal team and the external consultants, either from a top level with a top management team of the organization, with the middle management, and of course with the people in the other functions. And here is how actually the interaction is set up, and here is how the opportunity is created for the external consultants to better understand what the people in the organization need in order for them to make their job, to conduct their activities. And also it's an opportunity for the internal stakeholders to ask questions and to ask for clarifications when it comes about the recommendations that the advisors, either they are in-house or external, are making to the internal stakeholders, to the company's employees.
Thank you. Going a bit back to the tech side, I was wondering if the developments in the legal tech impacted or improved competition compliance in any way, and how can the legal industry embrace the integration of these technologies for compliance purposes?
The technological tools, the tech tools, should be part of the compliance program itself. And technology has an important role to play, and the tech tools should complement the man work and should add value in the risk assessment process. Therefore, in a world where we see such dynamic development of the technology, I cannot imagine the legal function operating without the technological tools, without the technology. Therefore, we can see the development of different technological tech support tools or platforms which are helping actually the compliance programs that the organization are implementing, like for example the e-learning tools implemented by a lot of the organizations out there for the training of their own employees. We can talk about the contract management systems, which are another tool to helping and supporting making, from an efficiency standpoint, the legal work within an organization. Therefore, as I said, the tech tools should complement the team members' work and should add value to the team's work in terms of the legal support.
That's great, thank you. And one last question with regard, how can general counsels, in-house counsel and external lawyers support industry associations in ensuring compliance with competition law and vice versa?
As you said, in Romania, we welcome actually, and we were very happy that the Competition Council has issued the guidelines to be observed by the trade associations when conducting their businesses. And it's important for the players in the market, namely for the trade associations, to have such a basis to start from in building their internal compliance strategy. The competition council set this tone for the trade associations to further build on their own compliance strategies. The role of either the in-house lawyers or the external consultants is a great one to be played in order to better support the trade associations, to better understand the guidelines issued and recommendations issued by the authority, to expand such recommendations and to build furthermore and more specifically, depending on the industry particularities, on the trade association compliance program, to deliver also adequate training to the trade association members in order to better set the rules, the name of the game, what are the risks and opportunities, and to be better prepared to conducting the trade association activity in a risk-free way.
Thank you very much, Elena, for your valuable input from the perspective of in-house lawyer. I was wondering if you have any question for me from my side.
Of course, because I talked a lot and I somehow feel guilty. I would like to ask you now, joking apart, to ask you as an expert in the competition area, and based on your expertise when dealing with your clients' projects, what are, in your view, the main risks when dealing with commercial business partners, or the main risks when it comes about mergers, and what are the most important factors, compliance factors to be considered from these two standpoints? So the commercial partnership between undertakings and from a merger and acquisition perspective.
Sure. So in terms of relation with commercial partners, at this moment, competition authorities are focusing very much their attention on restrictions related to online sales. So I would recommend all companies having activity related to e-commerce to pay very much attention to what they accept and what they cannot accept when it comes to their online sales. Also, competition authorities are still focusing very much on tender participation. So companies having an activity coming from this area should focus on how they structure their association with other companies and how they draft their financial and technical documentation so as to ensure that they do not raise concerns. From a merger law perspective, I would say that in the past years, I have seen an important and an increasing number of decisions where control was gained by minority shareholders. So I would recommend companies that acquire minority shareholders to not exclude a competition assessment, because depending on veto rights that they may preserve, merger clearance might be needed. So these are the main elements that I would focus at this moment.
Thank you very much. Very good insights. Thank you, Oana.
Thank you as well, Elena, for your valuable input. And I would like to thank Legal 500 for giving us the opportunity to discuss. It's been a very useful discussion for me, and I hope that it's the same for everyone that will listen to it.
A big thank you from myself as well to you, to Legal 500, and I really hope that our conversation will be found as an interesting one by the ones who will listen. Thank you again.
You've been listening to the Legal 500 Corporate Conversations series.